Good morning. So the title of today's session is The Rise of Tax Spiritualists. Hard to say the word even. Spirituality and tax, interesting topic. I think our guests can introduce themselves. We're going to go to introduction, but it's a really interesting topic. I think hopefully we're going to shoot from the hip on our views and comments. I think we're going to meander and cover a lot of topics, covering tax regulation, tax policy, how it all intertwines, different people's perspectives on tax, and how we see next 5 years going. From my perspective, I'll introduce myself before I hand over to the panel. Liam Stanbridge, I head up global tax product for BNY Mellon Asset Servicing Division. So I'm responsible for delivery of tax services to all our clients. We are the largest custodian in the world, 50 trillion of assets, touch 20% of the world's financial assets, hugely diverse client base. We provide tax services in 48 of our in excess of 100 markets from a custody perspective. We service over 100 countries of tax residents from an investor perspective. Investors range from retail to the extreme to public pensions, sovereigns, central banks, investment funds, hugely diverse. Every day we have uncertainty and challenges, and the way the world's evolved over the last 15 years is really interesting. I think from my perspective, we talk about spirituality, is it the letter of the law or the spirit of the law? These days, where previously I've been in tax 33 years, I used to work as a tax advisor. You picked up your tax legislation and you read the words and you figured out whether you're in scope or out of scope. I think more increasingly, tax has a broader base of stakeholders, okay? It's not just the tax authority and the taxpayer. I think there's reputation that comes into play. There's more broader public engagement on how rules are crafted and enforced. So it's a hell of a lot broader what we need to do on a day-to-day basis, right? It's not just picking up your taxes acts and reviewing the tax rules and figuring out whether you're good to go or not. So it's really interesting, and I think the dynamic has changed over the last couple of years, and it will continue to change, and there's obviously the political environment as well. I'm going to stop. I introduce myself. Let's do introductions, and then we can kick into the session.
Sure.
Tove.
Yes. Good morning, everyone. I'm Tove Ryding. I think I might be part of this broader base of stakeholders. I'm based in Brussels, and I come from the European Network on Debt and Development. And we are a coalition of development organizations, such as Oxfam, Christian Aid, Action Aid. And we look at poverty and inequality from an economic point of view. We have the observation that as far as we can see, there's no lack of money in the world. It doesn't seem to be that that's the problem. And within Eurodad, I lead the tax team. We also have teams working on debt and so forth. So we work together as a coalition to have positions on and influence the tax rules at global, regional, and national levels. And we're part of something bigger because I'm also elected as one of the 2 European representatives in what's known as the Global Allianz for Tax Justice. And there we have colleagues from Asia, Africa, Latin America, and North America. And we come together and coordinate on the global tax advocacy and campaigns that we do. And it's very inspiring to see that there really are movements all around the world that are picking up the issues of tax, and we have a lot of problems in common. And one of the things of the Global Alliance is that we are largely Southern-led, which means that our Southern colleagues have a majority when we make decisions. And the last thing I'll say about the stakeholders is that we coordinate a global working group that works on global tax rules. And it's expanding dramatically at the moment. We have more and more organizations that want to join us. The last ones to arrive in substantial numbers are the climate organizations. They're sitting in the climate negotiations right now, discussing a new global goal for climate finance. They have no idea how to mobilize the type of resources that are needed. And we have found a lot of interesting things to talk about, the tax and the climate movements. The human rights organizations arrived because they need funding for governments to deliver on people's rights. We have education organizations, we have healthcare organizations. Basically, we have all the different types of organizations that run into the same wall, which is that we do not have the public resources needed to implement the government commitments on development, on rights, on environment, and so forth. So I'll stop it there, but that's what I do for a day job.
Thank you, Tove. Ingolf, do you know?
Hi, I'm Ingolf. I'm working for Allianz Capital Partners, which is one of two asset managers of Allianz SE. And I'm personally concerned with the transaction structuring, tax structuring of our financial products in the alternative space for Allianz Capital Partner products and Allianz GI Global Investors products, investing more or less all over the world.
Thank you. I am not going to let Ali introduce himself. He is not addicted to sitting on podiums, by the way. He is kindly a substitute. I think we intended to have Paul Tang from MEP here, but unfortunately, he's more pressing business from a policymaker perspective. So Ali has kindly agreed to step in. He is not addicted to sitting on podiums. So thanks all. So I think a lot of things, this is going to be fluid, a lot of things. So one of the items, Ali, maybe come to you first, is there's been a lot of policy over the last 15 years. I know we talked about it. You go back to FATCA, that's my reference point, the Hire Act back in, was it 2009? I can't remember when it was, which sort of stimulated the transparency element. And then that obviously morphed into Trace was picked up again, and the TR of Trace was forgotten about, and then CRS was born. And then that morphed from an EU perspective into all the DACs. I think we're at, is it DAC 8 now, I think we're at. So there's been a lot of policy, and then, you know, I mean, that's around transparency. And then we have BEPS, which is changing fundamentally the way, you know, leveling issues around, you know, non-taxation, double deduction, etc., through hybrids, interest limitation, fundamentally shifting rules around how profits are taxed and where. A lot. Do you think policymakers to date have succeeded in their goals, both from a general policy perspective, but in the context of taxpayers and how they operate?
I think there's a two-tier market. Yeah. So there are people who are trying to do things the right way, and there are people, I mean, the dust has still to settle, because I think you rightly point out, we just last session we were talking about tax transparency. Tax transparency gave way to this idea of tax integrity, and firms getting their, you know, governance models right, and particularly sort of like those operating in the UK who have had the corporate criminal offence. That's there. The banking industry has had the code of practice. So they've required boards to take this seriously. But I think this new area that we're entering into, this is about denial of tax treaty benefits. And I think that changes the game quite considerably, particularly within the EU setting. And it's going to be, it's a shame Paul isn't here, because we could have asked him about 883. And 883 is really important because, I mean, I just saw it in passing, so please don't quote me on it, but I definitely recall seeing last week that they're about to drop the substance requirements from 883. Now, where will that leave things? I mean, the whole, but, you know, you've got faster, which is coming along, but, you know, I know, and you're a custodian and so on, people are celebrating faster, but the way I look at it, I think it's almost, it's you're legislating the ability to deny tax treaty benefits. So by putting a gate there and saying it's great, look at how much can flow in quickly. Well, yeah, but it's a gate, okay? And we've seen, I mean, we had a webinar, I think it was about a month ago, which was, we had Jonathan Schwartz, where we were talking about the MLI, the main purpose test. I mean, this is getting so subjective, and I think going back to the title, we all remember the days when we didn't have, we just used to have one that thick legislation, book of legislation. And now you just look at the, you know, it's books upon books. And there's no way you're going to get through this. I mean, it's not happening. And then you sort of like layer on top of that, but what is the intention of Parliament? Well, you know, is it for you and I to judge? And every time some inspector challenges and says, well, you know, this is against the spirit, well, mate, you know, that's your view, this is my view. In the old days, we used to say, let's see you in court. But I think what's happened is, as advisors, we definitely want to challenge. But I mean, I think generally we will say, we ask the question now is, from the client, what is your risk appetite? Because some are just not interested in picking a fight with tax authorities. So I think the whole game has changed quite considerably between the tax advisors, the tax authorities, and importantly, the taxpayers. So I think FI taxpayers, and you can probably see some recent cases in which financial institutions pick which fights. So a lot of FIs, I just find these days, just don't have the appetite to legislate, even though they think they're on good ground. The other change I would just sort of like say is tax authorities are not the same tax authorities. When I was starting my career, you actually had an intellectual debate and dialogue with them, and they would argue the point to, you know, technical points. These days there is, who am I going to upset, offend? Okay, there's no one from HMRC here. But you're just not getting the quality of advisors there. I mean, it's all sort of like, maybe it's because I'm getting old, they're all sort of like spotty teenagers, and you know, you're not going to have an intellectual, technical discussion with these guys. Anyway, I better shut up before I get myself in trouble.
I'm not going to agree or disagree with that. I think, you know, I mean, it's interesting. I think there's an observation. I think from a tax authority perspective, I think post-COVID, a lot of senior people with senior experience have left tax authorities, retired early or whatever, and there's a lot of experience and understanding that's left tax authorities, which creates a void for taxpayers. That's a separate topic, really interesting, which we won't go into. But I do think, you know, I mean, with all this, you know, EU legislation, multilateral instruments, a lot of complexity. The challenge is, I think, a lot of these rules are created by consensus, and they have to be because there's so many people that they need to satisfy or whatever, constituents from a policy-making perspective. But that consensus leads to subjectivity, which is a real issue from a certainty perspective.
No, it's
that's becoming more of a challenge, even in the context of what we do as a custodian, getting, you know, treaty relief under a double tax treaty. You know, it's becoming more subjective on issues. We have faster as well. It's the same as well. So a lot of complexity. I think a lot of uncertainty. Okay, maybe moving on. Playing that complexity to a more practical level. Asset management industry, Ingolf. How do you see, what are your challenges on a day-to-day basis regarding dealing with all this complexity of tax regulations?
So of course we as an asset manager are completely and totally affected by all these regulations.
It's a bit. It's okay.
Lucky
it's
enough,
fine, but I don't need it.
those new developments don't come as a surprise for us. I'm a big fan of BEPS because it's like looking into a glass ball. You knew what was coming. It was a well thought, several step approach on tackling tax avoidance. And we as an investment manager for institutional clients do not have a lot of risk appetite. We want to be compliant. We want to pay our fair share of taxes.
Okay, that's interesting.
But it seems that the new development, and this is maybe where the headline of spiritualism comes from, are drifting into uncertainty above fairness, because of course, the spirit of the law is simply part of the canon of how to interpret a law. Yeah? It's the letter of the law. You have your history development. You have the spirit, what it's meant. But especially the spirit part is getting stuffed with a lot of feeling, which is potentially way above the actual spirit of the law, because we are regulating technical issues here, and not general morality. And you, as the one working with these taxes, working with these rules, need to, or are maybe supposed to consider aspects which are outside of your pure capability. And now seeing that the eligibility for double tax treaties is affected. Double tax treaties don't fall from the sky, right? They're subject and the result of negotiation between countries, distributing taxes and monies on it. So they're typically quite good. And looking at our investor base, all our end investors pay taxes, are typically eligible to treaty protection. We have the countries where we invest in, but of course there's some way on how to get your monies from one place to another, and there are several layers in between, and diffuse regulations in this regard makes it very hard to only get to the result. And this is mainly my work as tax structuring person, so that in the end your investor pays the fair share of taxes and not an overburden of taxes, because, well, every jurisdiction typically want to have a grab of the piece of cake, and if you ask them, every jurisdiction involved wants to grab the whole cake. And we try to navigate through this way to get to, in the end, to a fair share. And not, and this is where BEPS was really helping. Yeah? It's not about wide income, non-taxation. Yeah? The effect of hybrid mismatches and reverse hybrid mismatches are addressed. But this is what makes our daily life very, very complicated. That we get addressed by regulations which seem to fill a headline, and then are not completely considered in an area where we are not only on negotiation level. It's, public law is hierarchy. There's one stating what you need to do, and there's one who needs to comply. But in such a level, you need to be very, very specific on what you want from your taxpayer. And I hope that this spirit gets back into lawmaking as well.
Interesting. So from a custodian perspective, I think, for what we do day to day, I think the complexity in the rules, interpretation of the rules, tax authorities reading between the lines, which is becoming more of an issue. I think we face challenges on a day-to-day basis, certainty for our clients about getting entitlements under a treaty, length of time getting those entitlements, information requests. We're being overwhelmed with information requests from tax authorities. And again, it's sporadic but increasing in volume. I think from an organizational perspective as well, and I sort of alluded to this, we don't necessarily just look at what our role is in the context of dealing with a tax reclaim or tax relief, like reference to the tax authority. We have regulations because we're a regulated institution, and some of those regulations deal with tax evasion, financial crime, so we need to look at financial crimes as well. Okay, and then just more broadly, we have our broader reputation. So it's a three-legged stool, right? It's not just the tax authorities, and that's becoming more and more important. And whether, getting a tax opinion from a client confirming that they've looked at X and it's all comfortable, is that it? I don't think so. I think you need to look at the broader perspective about reputation. Even though satisfy the rules, is it, not necessarily is in the spirit of the law, but is it something generally you're comfortable with? And then when you're a regulated institution in one jurisdiction, but you're processing entitlement for a client in another institution, the regulator may have a different view than the tax authority when you're filing the reclaim, but you have a responsibility to both. So it's a complex web,
and some of them are
and
supportive, some of them
but
are
I think
not,
it's not just tax law, it is reputation,
could
it is then dealing with our regulators as well.
we did a lot of
So a lot more
investments.
complexity.
And now
So I'm going to hand it
paid
over
off.
to you now. Question.
And now
Fairness, more to be done
second year in a row where the
in
results
the context of the
are
rules.
good.
What's your perspective with the
Great.
last 15 years?
They are
Increased
like,
transparency,
I don't know,
rules
Manchester
trying to
United
determine
or,
taxing rights.
FC Bayern Munich, right? They always
Are we
want to be
moving
on top
to a
and,
perceived
sometimes
fair
you're just
society?
second or third, right? And that's still fine.
I think fairness is something we need to have as a public discussion, and it really brings to the point that we need to look at the democratic part of the way that global tax rules are set.
Sorry.
I'll get back to that. But first to say, I think it's great to be on this panel, and thank you, Ali, for being very determined to make sure that I was part of this. And of course, maybe I'm a bit the odd animal in the group here, but I'm part of my own silo of civil society, where sitting and saying 2% global wealth tax, it's completely mainstream, it's uncontroversial, everyone's, yes, of course. And then we have another silo here in the business discussion, and I think meeting and talking, that is extremely important, but one thing that sometimes perhaps surprises us a bit is that we have less agreement sometimes than you would expect, but I think we found a few here. When you say that you're a fan of BEPS, excellent, there we have a point of disagreement.
Just one.
And
For me, it's
to start with BEPS, one of the things that fascinated me was when BEPS came out in 2015.
Well, tomorrow
And
is
it was
good,
sold as a
tomorrow is good,
simplification.
and that's about it. Over the
I
weekend,
remember we
have a,
took the
Saturday
environmentally
it's a
irresponsible
escape
decision of
room
trying to
with
print
a
the
couple of
thing,
kids
and it's almost
then
2,000
make up
pages.
what have you.
That was before the additional guidance to the guidance
Sunday,
arrived. I lost track of the number of pages that BEPS has reached by now, but simplification. We found common ground with a lot of different types of people in the business industry in saying it did not simplify the system. And I was in an expert group in the EU where we also meet business on the day when the concept behind Pillar 1 was introduced to us. And it was astonishing because we were sitting and saying, look, civil society, we want unitary taxation. We want taxation on the global profit. And a lot of the representatives of business, they want the transfer pricing system and arm's length principle. None of us were saying, let's do both things at once. And taking a part of the profit of a small group of companies and then trying to run a type of tax that is fundamentally different from the way the rest of the system is running, that sure didn't make things simpler either. So the issue of complexity is one where we sometimes find commonality, and that's also why I can't say that I was a fan of BEPS. A second reason why I wasn't a fan of BEPS was because we didn't feel it actually solved the fundamental problems. We called it a sticking plaster. And we were a bit expecting, well, the problems still exist, so, you know, we can just lean back. There's going to be more tax scandals. The political momentum for changing the rules is going to come back. But we had an agreement with business on the point that it's politically too chaotic. Tax scandal, urgent change, throw a few more ducks at the problem. And this cycle of political urgency and very urgent to change. And then the flip side is that then they come with some more confusing rules, and then they oversell it. Pillar 2, we've told the world that all multinational corporations now pay 15% in tax. In this room, we know that that's not true. So it's only a matter of time before we're going to see evidence that, oh, they didn't pay 15%. I mean, 85% of the world's multinational corporations aren't even covered by Pillar 2. And the ones that are covered can still pay less than 15%. And the thing that makes it a scandal is that, but you said that things were different now. And I think this ongoing overselling of the rules and then this counter response. It's a very difficult environment to work in. And ever since I arrived in tax over 10 years ago, we've had this almost every second year. Wow, there are new rules. We never thought this would happen. We never thought that would happen. And it's an extremely unstable political environment. Let alone the fact, and this will be my last point for now, is that we never had a global agreement on tax. We have rules that we call them global tax rules, but we actually don't have a truly global decision on basic principles, objectives, and ways of working. We have that on climate, on tobacco control, on biodiversity, you name it. We do not have it on tax. And that creates a lot of political instability. I'll get back to that later, probably.
Interesting. So, I mean, like the OECD has been very busy over the last 15 years. Like it created CRS. It ran the BEPS project. A lot of work done by the OECD creating rules that didn't exist and prevented carnage, which would have happened otherwise, which would have been fragmented rules, governments smashing and grabbing, taxing. Like we need to remember, I mean, 10 years ago it was getting quite heated from a policy-making perspective around taxing, right? So I think the OECD stepped in and did a lot of work to try and create some sort of consensus, trying to bring a bit of sanity to the insanity. But I'm sure it's not perfect, right? So there's a lot more work to do. But so from your perspective, like when we talk about the UN, developed countries being the decision makers, good experience, bad experience, does it need to change? If so, why? And how will it change? There's a lot in that question, sorry.
No, it's good. Do we have bad experience with developing countries being decision makers? We sometimes have bad experience with all governments being decision makers, and it really goes to this point of democracy. And it's true, the UN process has started. And there's a few things that are interesting about it. The first thing is that you can watch it live on the webcast. Yep. Secondly, the negotiating text was put on the internet Friday night. Odd timing, but this is how it is. The negotiating text is out there. Now we can make submissions. So we're all drafting submissions. Governments are drafting submissions. They get put on the website as well. You have a transparency that you haven't had before. And that is a way of creating ownership, public debate, making sure that parliaments actually know what's going on before the rules are decided. And also from civil society side, we were not happy that we couldn't read the text before it was adopted. You say that with BEPS you could see what was coming. We couldn't, because it was behind closed doors. So the whole democratic element of it, and the fact that you have a transparent negotiation between governments, also means that we can hold our governments to account, all of us. We can actually engage with the process in a different way. And then indeed, the position of developing countries, I think it's part of the instability that we've seen in the system. We have a lot of EU countries saying now that it was so surprising that this came. If it was surprising, you have not been listening to the Africa group, because actually it's 5 years ago since they said, we want a UN convention on tax. And what is this animal? It goes to this point that we've never had a global agreement on tax. We've never actually settled the basic objectives, rules, principles, and so forth. It also means we don't have anything stopping countries from going home and inventing their own global tax rules and applying them unilaterally. And in fact, when developed countries try and tell developing countries, you're not allowed to do that, they typically respond, well, you started. So for once, we actually have a fundamental rethink of the way that we set global tax rules, but we also have a real chance to get a truly global agreement. And we're very positive about that.
Interesting. Just from my experience, and this is just my own personal view, I thought the OECD was very transparent, actually. I thought there was a lot of transparency, a lot of interaction with stakeholders. So I would have probably a different experience with the OECD, but that's maybe just my own personal experience. So it's really interesting, the broader, beyond developed countries perspective. How do you think that will play out from a taxing, like what's practically what it's going to mean? Does that mean more taxation goes to where, for example, asset management industry, where the asset is located, the asset generating the value, there's more taxing rights there, you know, in the traditional basis of double tax treaties, which for dividends and interest generally push taxing rights to the country of residence, that's actually going to be inverted. Is that logically where we're?
Mm-hmm. Yeah, a few things that are coming up. First, I think I also disagree on the point that consensus has to lead to subjectivity. I think there is coming into the world of tax, I used to work on international environmental law. It was a different world, and the lack of clarity in the rules, for me, is something that is much worse in tax than it is in, for example, climate, environmental protections. And simplifying the rules is one of the first things developing countries put on the agenda. I think that's very interesting. And secondly, where is it going from here? I think we can see two avenues. One is the avenue where all countries stay at the table. We had 48 countries vote no to starting this process in November, and we had 125 vote yes. The 48 countries that voted no, they came back to the table when the negotiations started, and right now they're there. So there's one scenario where we keep the current situation and all countries participate. There is also an additional avenue, and the Africa group has been quite clear on this, is that if some countries refuse to cooperate and negotiate, the rest of the group is likely to move on as their own group. And this goes to the discussion about consensus decision-making. I don't hear a disagreement when it comes to discussing the rules of how global tax rules are actually set in a UN Framework Convention. I don't think that is the question. No country can be forced to sign on to a UN convention, but also within the convention, you normally have a higher decision-making threshold. Right now, we have majority decision-making in the UN. That's a complex area, but the fact of the matter is that right now, we're looking at who's going to join the negotiations and not. And the 48 countries that voted no have asked for consensus decision-making right after they voted no. They want a veto right. Of course, the Africa group is not ready to say yes to that because they haven't yet taken the proposal off the table that would mean that if you don't want to cooperate, we're going to go on our own. But one thing that we've been very happy to see is that there is an openness, and right now it looks like from all sides, to try and find a truly global agreement. That's what we want. It looks like that's what developing countries want as well. And one of the things that we really welcome about this approach is that right now, the group is deciding who wants to be at the table or not, but everyone is invited. And they've been invited before the rules are adopted, rather than after, which is the opposite of what the OECD did on BEPS.
Interesting. I think we've about 5 minutes. We're under time pressure, so I'm just going to go around with questions. The consensus point is interesting, and I think, so as my perspective, it's the consensus around not wanting to deal with an issue that creates uncertainty, not consent. So, give you a prime example. We have faster directive, which is highly topical in my world. It's, different perspectives on it. There is a concept that's been mulling around the world for years, the concept of beneficial ownership, right? Hasn't been dealt with faster. People have refused to grasp the fundamental issue about what is beneficial ownership. That's a real problem. I have 5 minutes left, so I'm going to come around. So maybe I'll go around the table, views on the topic. Letter of the law, spirit of the law. What do we think going forward? Ingolf, would it kick off to you from an asset manager perspective?
I'm reluctant to think that those anticipated global solutions are actually making things easier, because the facts are very, very complicated. And even if you agree on a global level of some fundamental basic rules, tax is a very technical topic. It refers to accounting and how to I acknowledge income and how do I qualify it. And thinking that if you make a simple set of rules, you make a simple set of law and working regime, I think it will be confronted with the complexity of hundreds of jurisdictions treating and calculating and accounting taxes for very, very differently. And also the aspect of thinking that making rules simple makes them fairer is also very unlikely, because if the rule is simple, there might be a lot of ways to wiggle around it. And so therefore for BEPS, there were people who knew how certain things were structured to avoid taxes, and they really tackled it. And it's not that it didn't have an effect, it had a huge effect. It had a super huge effect on how taxes are structured. And if you say now we have this global concept, you'll figure out, and you see it with Pillar 2. You think you make it simple, you think you make it true for the whole world, but the whole world is completely different. Countries have completely different needs. Some countries need to put their own taxation in a way to attract foreign monies or something. It's not the same, whereas other countries don't need this. They're the ones everybody's investing in anyway, so they can play their taxes completely different. Taxes are the result of negotiations between countries in the end, if we are looking at the global basis. And it's also connected to power, so thinking that an outside regulation puts some fairness to it is a very, very hopeful thought, but maybe not true in the essence. And looking at withholding taxes and the complexity as a custody bank, you will see that a lot of countries agree, in this case, I will refrain from tax it, but then, in the contrary, as every jurisdiction has the intention to keep its taxes, they make it super hard for you to get it back. So you have really, really contradictory players here, and therefore, I would say you need to acknowledge that the world is complicated, and don't put too much hope in thinking that making things on the word of the law, on the letter of the law, simple, makes it makes it fair and easy in the spirit of the law.
Yeah, I think it's really interesting. I think really interesting point, which is a topic for another discussion. Different priorities different countries have from a taxing perspective. Even within the EU, some are hyper focused on withholding taxes being paid out to non-residents, really hyper. Because of past experiences, and you can't argue with their perspective. Some countries are small open economies, want to get direct investment in. It's a non-issue. So you have that dynamic, and that plays out on a day-to-day basis as a custodian. Ali, handing over to you, thoughts as a tax advisor?
Yeah, as a tax advisor, it is a lot more complicated, and I agree with you that, of course, you have the law, and you work with that. But I think it's become a lot more complex in the sense that it's not just the interpretation or the rules anymore. I mean, it has moved from being a science into an art. And, tongue-in-cheek, Rise of the Tax Spiritualists. I mean, sounds like a Jedi movie or something. I mean, you have to be taught in the deep arts of how do you handle that. So I think it's, little nod to literature is moving from sense to sensibilities. And it is very much about aesthetic judgments now. And I'm not saying it takes away the underlying science. You still have to do everything that you did yesterday, but now you layer it with another level of understanding. And that is quite interesting, because now you as a tax advisor, not just interpreting, you're actually calibrating that tax advice according to your taxpayer, your client. And I have a particular client who has got into this odd habit that instead of sort of like saying, here's a piece of advice, could you give it to me? He says, no, don't put anything in writing, not even the email. I'm going to send you the fact pattern. I want to have a call with you. And we have a call, and then he says, oh, can you now put it in writing? And sometimes he says, okay, I've got what I needed. I don't know what he's doing, but you see, it's just redrawn the whole understanding. It's very difficult. And I think it's a very difficult position to sustain. And I think filing positions, these regimes that we've been talking about, tax transparency, they're going to make things very difficult. I mean, FATCA and CRS is easy because it's methodical. This is, you got to follow this process, out pops the number. But when you start getting into things like the world you occupy, you've got to worry about what Tove is going to send next week.
That's true. Or today. Anyway, go.
Yes, no, it's true. But one of the things that we actually do tend to find agreement on is that we can't have tax rules. Tax rules are extremely forceful. We can't have unclear tax rules that allows everyone to sit and say, how am I feeling today? Also because the uncertainty, interpreting the spirit, I mean, some of the advanced pricing agreements that are subject to state aid cases go back to the early 90s. So sitting there and thinking, how are people spiritually going to understand this law 20 years from now and more? It's a mission impossible, and it really goes back to the fact that we cannot ignore the policymakers in this issue. We need clear tax laws. I do acknowledge that the tax world is complicated, but I do not acknowledge that it has to be like that. And coming from this other world of international environmental law, climate is complicated. You have the tundra, and then it's emitting, and how do we measure, and what gas should count as what, and how do we regulate this complexity? Tax is something we made up. We made up these rules. There's no natural reason why this should be so complicated. Of course, it'll have complexities, but we should not acknowledge government's right to not cooperate, not communicate, and create tax rules that stick in all directions.
Excellent. I think I'm going to get the last word on this one, actually, if we don't mind. As a moderator, am I allowed, am I? And then we'll close. So listen, I completely agree, absolutely agree. I think the letter law is really important, but the spirit around your risk appetite as a financial organization, expectations of regulators, it's more important, not just the letter law. So it's going back to Ali's point, it's getting layered. It's not just a letter.
So your LinkedIn profile is going to say tax spiritualist now.
Yeah, shaman or whatever you call them. So thanks, really interesting. We could have gone on for a while longer. But thank you very much to my guests. And thank you, good to see you guys.